Can I have the attorney representing the public defender's office down there in Osceola state your name for the record, please?
Good morning, Judge Alicia Smith on behalf of the Public Defender's Office.
All right, I'll have the assistant state attorney present here state his name for the record. All right, when I call your name coming up to the podium, we're still waiting for the interpreter to call in, so we'll come back to those cases in a moment. First case, last name spelled B-H-I-M-A-N-I.
Over here.
So there's probable cause to believe that you committed the offense of driving under the influence. The bond in your case will be set at $2,500. It's a higher bond than it was originally charged with because, or set forth on the bond schedule. I'm not going to revoke the conditions of release you have on the Osceola case or the Orange County case. But that doesn't mean that the state can't go in front of either of those judges and ask either of those judges to do it. You understand?
Yes, sir.
And let's see, can you afford a lawyer or do you need the public defender?
I have a private lawyer, attorney, David Chico in Celebration, Florida.
Okay. All right, thank you.
Thank you.
The next case is Keisha, last name Cruz-Ramos.
She needs the interpreter.
All right, we'll come back to that case. Next case is last name Bowman, first name Q-U-E-N-D-R-I-C-U-S. You have a warrant for your arrest for a violation of probation where the bond is no bond. Can you afford a private attorney or do you need attorneys at the public defender's office?
Public defender.
All right, they'll be appointed to represent you. All right, they'll have to go in front of the judge assigned to the case to try to get you a bond. The next case is Michael, last name C-O-N-C-A-N-N-O-N. There's probable cause, sir, to believe that you possessed a controlled substance, methamphetamine, and you possessed drug paraphernalia. I see that you qualify for pretrial release. You'll be on pretrial release with the conditions of don't possess any drugs that are not lawfully prescribed to you. You'll be subject to random tests to make sure you're not possessing or using any drugs that are not prescribed to you. Do you understand?
Yes.
Can you afford a lawyer or do you need the public defender's office to represent you?
Public defender.
All right, they'll be appointed. Next case is Malcolm Davidson.
He bonded, Judge.
Thank you. Is that the interpreter? Got it. Next case is Brittany Gibson. Ms. Gibson, there's probable cause to believe that you committed the offense of trespass. It appears that you qualify for pretrial release. Let me just ask, pretrial release, any prior criminal history on this defendant?
She has two priors, 07 Dwellis, 2013 battery, both of them dropped.
All right, you're be released on pretrial release with the condition you're not allowed to return to the location of the offense. If you violate the condition of release, it will cause you to be right back in custody. Do you understand?
Yes, I understand.
All right, thank you. Can you afford a lawyer or do you need the public defender's office?
I don't know right now.
That's all right.
She
You'll
did
be,
complete an application, Judge.
well, does she qualify under the application? I don't have it in front of me.
Yes, Judge. Yes, Judge. The clerk said she qualified.
All right, there, appoint the public defender then. All right, thank you. You can always hire a private attorney and they can substitute for the public defender. Next case is Gregory
Okay.
Landreth.
And Your Honor, on this one, although the charges do meet criteria, after reading the arrest affidavit, I have concerns that he would be an appropriate candidate for PTR.
I want to make sure you said is inappropriate or not inappropriate.
Not appropriate for PTR.
Mr. Landreth, there is probable cause for the offense of possession of methamphetamine and possession of drug paraphernalia. I'll appoint the office of the public defender to represent you. The bond on count number 1 is $2,500, and the bond on count number 2 is going to be $100. Do you understand?
Yes.
All right, thank you.
Judge, just for the record, Because he does qualify, I would ask for pretrial release. I understand PTR saying he does qualify, however, they don't think he'd be a good candidate, but because he does qualify and the charges qualify, I would ask for PTR.
I appreciate your request. If you can't afford to post the bond, you can always ask the judge assigned to the case for that. All right, thank you. Next case is Carlos Lopez Rosario.
He needs the interpreter.
All right, we'll pass on that one. Delisha Marshall.
She bonded.
Next case I have is Antonio Medina.
Needs the interpreter.
All right, we'll come back to that. Omar Mendez Gray.
Also interpreter.
Pedro Moctezuma-Ramos. All right, on your case here, you're in custody on a violation of probation for a misdemeanor at no bond. The public defender's office will be appointed to represent you. They'll have to go in front of the judge assigned to the case to try to get you a bond. Do you understand?
Yes.
All right, thank you, sir. Next case is Courtney Nip, NIPP. All right, on your case, there's probable cause to believe you committed a petty theft at Walmart, or order that you not return to Walmart. And there's a note here that says you don't qualify for pretrial release, so the bond is going to be $500 with the condition of don't return to Walmart. I'll appoint the Office of the Public Defender to represent you. Do you understand?
Yes.
All right, thank you. G?
Your Honor, that was just for your information.
Okay, so I'll take no action on those. All right, thank you. Jason Robinson? You're in custody on a no bond warrant for a violation of probation in a felony case. Your lawyer will have to go in front of the judge assigned to the case to try to get you a bond. Do you understand?
Yes, sir.
All right, thank you. Next case is last name Vasquez
Are
Negron.
you? He bonded, but are you appointing the public defender as to Mr. Robinson? He did complete an application and
All right,
was
yes,
determined
ma'am.
he qualified.
Yes, ma'am. Okay, you said so Vasquez Negron bonded?
Yes, Judge.
Next case is Peter John Beattie, B-A-T-T-I-E.
He's coming, Judge. He's in a wheelchair.
All right, there's probable cause to believe the offense occurred. Any prior criminal
Judge, are
history?
you finding
on this?
probable?
Yes.
He has no convictions. He had a battery in 2017, which was dropped.
All right, so on count number 1, it'll be pretrial release. On count number 2, 1,000 in pretrial release. And count number 3, pretrial release. Don't return to the location of the offense.
Judge, just for the record, you did say straight pretrial release as to count 1, the criminal mischief. I was arguing there was no PC, but if you're gonna do straight PTR, then I can withdraw it.
All right. So, yes, ma'am. All right, thank you.
Thank you, Your Honor. Your Honor, can I say something quickly?
Say it first to your lawyer, and she'll make sure you don't say something that'll hurt your case. You'll be amazed what people say.
You got a bond for $1,000. And the public defender's office appointed?
Yes, ma'am. Joshua Harvey. Mr. Harvey, the public defender's office will represent you on the 2 cases. One is a violation of probation where you're being held no bond. The other is a theft and also a burglary. The bond on the theft and burglary are 500 and 1,000. Don't return to the scene of the offense and don't possess any weapons or firearms. Your lawyer will have to go in front of the judge assigned to the VOP to try to get you a bond. Do you understand?
Yes, sir.
All right, thank you. All right, so my understanding is the only cases that are left are the interpreter cases there.
Yes, Judge.
Good morning, Your Honor. Interpreters on the line?
All right, and you were sworn in earlier, juvenile, correct?
I have not, Your Honor. That was Dahlia that covered juvenile this morning. This is Astrid Rodriguez, Your Honor.
All right, thank you. So we'll have the clerk swear you in.
Swear affirm to translate from Spanish for English and English to Spanish the testimony given today.
I do. Astrid Rodriguez, certified Spanish interpreter.
All right, thank you. The first case is Keisha Cruz-Ramos.
Keisha Cruz Ramos.
Your name, please.
Su nombre, por favor?
Keisha Cruz.
Keisha Cruz.
There's probable cause to believe that you committed a battery on a family or household member as that phrase is defined by law.
Hay motivos fundados de que usted cometió el delito de agresión física en un familiar o alguien que vive en su misma casa, según dice la ley.
I have to order that you have absolutely no contact with the listed victim
Tengo que ordenarle que no tenga contacto en absoluto con la víctima que ha sido nombrada.
No contact means no good or bad contact, no direct or indirect contact.
Se le prohíbe contacto, eso significa que no puede tener contacto ni bueno ni malo, no puede tener contacto directo con esa persona ni contacto indirecto.
If you violate the no contact order, it will cause you to be right back in jail.
Si usted viola la orden donde se le prohíbe tener contacto, usted será regresada a la cárcel.
So it's no contact with the victim. You have to maintain a separate residence from the victim. Don't possess any weapons or firearms, and don't go back to the victim's residence.
Se le prohíbe tener contacto con la víctima, se le prohíbe regresar a la residencia, se le prohíbe tener armas o armas de fuego y no puede regresar al lugar de los hechos.
Those will be your conditions of pretrial release, but you have to post a bond of $250 first to be on pretrial release.
Estas van a ser sus condiciones junto con libertad previa juicio, pero usted tendrá que pagar una fianza de $250.
Do you understand?
¿Entiende?
Sí.
Yes.
And the public defender's office will represent you. That's a representative to your right. She's with the public defender's office.
La oficina del defensor público va a representarles a la persona que está a su derecha. Ella es de la oficina del defensor público.
Okay.
Thank you. Carlos Lopez Rosario.
Carlos López Rosario.
Your name, please.
Su nombre, por favor.
Carlos López Rosario.
Carlos López Rosario.
There's probable cause to believe that you possessed heroin and that you possessed drug paraphernalia.
Hay motivo fundado para la acusación de que usted tenía en su posesión heroína y arminículos para las drogas.
The bond is $2,500 on count 1 and $500 on count 2. Actually, excuse me, count 2 will be $100. Is the interpreter still there?
Can you hear me, Your Honor?
I heard that part, but it,
Okay, I'm still connected, but I did lose my canvas. I think it's okay because I'm on the loudspeaker. I'm reconnecting, but as long as you can hear me, then it's fine. But I did lose you for a moment. I did hear the charges, which I conveyed, but I did not hear the amount of bond or anything you may have said after that.
all right, thank you. So you're charged with possession of heroin and possession of drug paraphernalia. There is probable cause. The bond is $2,500 on count 1 and $100 on count 2.
150 en el segundo cargo.
Yes, okay.
So I can't, to the interpreter, I only heard a sentence.
I think she only said the bond amount, Judge.
Got it, all right. The individual to your right is with the Public Defender's Office. She'll represent you. So, as the jail, are you able to hear the interpreter?
Before, not now. The last thing I heard her say was the bond amount.
Okay.
Are you able to hear me now, Your Honor?
Now we can. All right, so let's try.
I'm sorry, Your Honor. I heard you. I heard the charges. The bond on the first charge is $2,500, and what was the second bond?
$100.
$100. To the right was representing him. Thank you. I'll repeat that to him in Spanish. Señor, su fianza en el primer cargo es $2,500 y la fianza en el segundo cargo es $100. La señora parada a su lado es su abogada. Ella es de la oficina del defensor público.
Right. Do you understand, sir?
¿Entiende, señor?
Okay. Sí, okay.
Yes.
All right, thank you.
Okay. Yes, okay. Gracias.
The next case is Antonio Medina.
Antonio Medina?
Sí.
Yes.
All right, you have two cases here today.
Usted tiene dos casos aquí hoy día.
Your case is going to be rolled over to tomorrow for the determination of whether or not there's probable cause.
Su caso va a ser esto aplazado hasta mañana para ver si hay motivo fundado.
The police reports that I have here are just listing the elements without any facts. All right, I don't know if the interpreter is still there.
The interpreter is here, Your Honor. Can you hear me?
I can hear that part, but I didn't hear the interpretation of anything about the PC and rolling it till tomorrow. Yeah.
Señor, el caso ha sido aplazado hasta el día de mañana para determinar si hay motivo fundado para proceder con esta acusación.
In the meantime, you can post the bond. Otherwise, if you don't post the bonds as you were originally arrested for, we'll see you tomorrow to find out whether there's probable cause or not.
Mientras tanto, usted podría salir bajo fianza según la fianza que ya ha sido fijada previamente. De no ser así, lo veremos mañana.
And then for pretrial release, I'm not taking any action on the potential VOP because doesn't appear to be probable cause at this point.
No voy a tomar acción alguna en la fianza previa en el caso que está bajo probatoria debido a que en este caso aún no hay hallado motivo fundado, así es que no hay motivo para violar la probatoria en este momento.
All right, thank you all. Next case
Gracias.
is Omar Mendez Gray. Oh, public defender pointed on that last case if I didn't say it.
Se le asigna el defensor público en el caso previo.
Hi there, you Omar Mendez Gray?
¿Usted es Omar Méndez Gray? Yes.
All right, I'll appoint the public defender to represent you. There is probable cause to believe that you committed the offense of battery by strangulation.
Voy a nombrar al defensor público para representarle. ¿Encuentra motivo fundado de que usted ha sido acusado de agresión por estrangulación?
I'm ordering that you have absolutely no contact with the listed victim, and no contact means no good contact, no bad contact, no indirect contact, and no direct contact.
Le prohíbo tener contacto con la supuesta víctima. En este caso, el contacto se prohíbe ser, no importa que sea contacto bueno, malo, directo o indirecto, no puede tener contacto en lo absoluto.
Do you understand so far?
¿Entiende hasta el momento?
Sí.
Yes.
All right, so it's the no contact, then you have to maintain a separate residence from the victim, not possess any weapons or firearms, and no return to where the victim resides.
No puede tener contacto, no puede poseer armas o armas de fuego, no puede regresar al donde viva la víctima.
Your bond on the case is $1,500 with those conditions.
La fianza en este caso es $1,500 con las condiciones que ya he nombrado.
All right, do you understand?
¿Entiende?
Sí.
Yes.
All right, thank you. Is there any
Bien,
other
gracias.
any other cases in Osceola that we haven't addressed?
No, Judge.
All right, thank you.
Thank you. Have a good day.
You too. All right, so are we doing the move-ups and then interpreters? Is that what we're doing? Doing interpreters first, okay. Are there people downstairs that are being brought up for any of the, any of the victims or people that were wanting to be?
Just went downstairs.
All right, so we'll wait a moment to find out if anyone's coming up.
Your Honor.
Yes, ma'am.
So I connect from home from a laptop, and I think there's a little glitch with it, which every now and then you freeze, and that's when then you cannot hear me when I'm interpreting. Dalia is at the courthouse because I'm heading there. We're working on a little project for Judge Myers. So she's at the courthouse, so I'm going to disconnect, and she's going to connect, and we shouldn't have any issues with the connection.
All right, sounds good.
But she's already there.
All right,
Okay?
yes, ma'am. All right, thank you.
Thank you. Have a good day.
You too.
Thank you.
Good morning, Your Honor. This is Dalia Romero, Spanish interpreter on the line, already sworn in this morning.
All right, I had not pressed the button for the recording for the record, so can you say that again?
Dalia Romero, state certified Spanish interpreter, already sworn in today.
All right, thank you. Now that we're here at the, from the BRC, I'll have the Assistant Public Defender representing here state his name for the record.
Darren Chambers on behalf of the Public Defender's Office.
All right, we'll have the state put his name again.
Ibrahim Mark for the state.
All right, thank you. Your name, please. Okay, so the interpreter, okay, there we go.
Yadira Badillo.
Thank you. There's probable cause to believe that the offense of burglary of a conveyance, battery, and domestic violence occurred. Now, ultimately, you qualify for pretrial release, so you won't have to post any money to get out of jail. But I want to go over the conditions of release just to make sure that there's no confusion, because I don't want you to accidentally find yourself back in jail. I have to order that you have absolutely no contact with any of the three listed victims, Genesis Felipe, Jose Badillo, and Nicole Rivera. No contact means no good or bad contact, no direct or indirect contact. If you violate any of the no contact conditions, it'll cause you to be right back here in custody. So, for example, if you were to send money or flowers to the victim, that would still be a violation of the no contact order, even if other people might have thought that would be a nice gesture. So, no contact. Your lawyer is still allowed to defend you. Your lawyer can always have the case brought back in front of the judge assigned to the case to try to modify the conditions, but unless a judge orders some change, for as long as the case is pending, it remains no contact. Do you understand all of that?
Yes.
All right, I also have to order that you maintain a separate residence from them, that you don't possess any weapons or firearms, and you don't go to the victim's residence. Do you understand all of that?
Correct, that's right.
All right, so you'll be, like I said, you'll be released without having to post any money. Abide by those conditions. Can you afford an attorney, or do you need me to appoint the public defender?
I do need the public defender.
All right, I'll appoint their office to represent you. All right, thank you.
Thank you.
Your name, please, sir?
Osivan Illas Peyot.
Osivan Illas Peyot.
There's probable cause to believe that you committed an aggravated assault, a battery, and a resisting without violence. I'm required to order that you have absolutely no contact with the listed victim. No contact means no good or bad contact, no direct or indirect contact. It's further described in that no contact order. If you read and understood what no contact means, can you please tell us for the record here? I see you shaking your head.
Yes.
Thank you. We just have to make sure that there's a.
Yes.
We just need to make sure that there's a record of whatever it is that anyone's answers are in here. All right, so as I said, no contact with the victim. You have to maintain a separate residence. Don't possess any weapons or firearms, and you're not allowed to return to the victim's residence. The bond on the case is 1,000 on count 1, 100 on count 2, and 100 on count 3. Do you understand?
Sí.
Yes.
All right, thank you, sir.
Sí, ¿cuánto es de fianza?
Yes, so how much is the bond?
The total is 1,000 plus 100 plus 100, so it's $1,200.
A saber si tenía el 10% de eso.
Can I pay 10% for that?
There are certain bonds, people, that are sureties, they also call them, that will allow you to post a percentage only instead of the full amount, but that's between you and them.
Okay.
All right, thank you, sir. Oh, yes. And your PD's representing him, I thought I said that, but just to be sure. I might not have, but now they're pointing. Your name, please.
Giancarlos Echevarría. Sí.
Giancarlos Echevarria.
Sir, there's probable cause to believe you committed a battery and a resisting without violence. I have to order that you have no contact with the listed victim. No contact is described on that form there. If you've read it and understood it, go ahead and sign it. In addition to the no contact, I'm ordering you to maintain a separate residence from the victim, that you don't possess any weapons or firearms, and you don't go to the victim's residence. The bond on the case is going to be 500 on count 1 and 100 on count 2. Do you understand?
I'm sorry, Your Honor. Didn't get a response.
All right, so did you understand those conditions? I need to make sure you answer verbally so that there's a record of whatever answer is, whether it's yes or no, or I don't understand the question.
Sí entiendo.
Yes, I understand.
All right, thank you, sir.
And were you appointed on that case?
Yes, sir. Was that the last of the interpreter cases? All right. All right, thank you, interpreter.
You're welcome, Your Honor. Have a great day.
You too. For those of you who are in the audience, if we call a case that you believe that you're somehow related or connected to, the corrections officer will assist you to go into that, well, the security at least, will assist you in going to that little room over there, and we'll hear from you then. All right, sir, if you step up to the podium and tell us your name, please.
Edward Henry Powell Jr. Your Honor.
Your Honor, for the record, I have a probable cause argument for Mr. Powell.
All right, we'll come back to him in just hold on just a moment. I had a Matthew Milano.
Medical, Your Honor.
All right, so on his Mr. Milano, there's probable cause to believe the offense. And let's see. He qualifies for a pretrial release, so pretrial release with random urinalysis, not allowed to possess any drugs without a prescription, subject to random tests. We'll see him tomorrow if he's still here. Pretrial, no drugs, random urinalysis. Yeah, Mr. Pollock, there's no probable cause for the offense. I'll have to reset it for tomorrow if you're still here. In the meantime, your bond is $1,000. The police report references some other report that's not attached. Maybe that will establish probable cause, but I have no idea. So we'll see you tomorrow if you're still here. Robert Roman Fuentes? Have a good day. Are you Mr. Roman Fuentes?
Yes, sir.
You're in custody on 4 warrants for various things. There's a failure to appear capias that was issued in 2019, 3522. Set the bond at no bond. Then a capias was issued in case number 2916. After you failed, well, let's see. Make sure I got all this right. 3522 capias failure to appear. Then you had capias issued in 2916 for a capias issued after they believe you failed to appear. Then in case 2985, a capias was issued when you allegedly failed to appear. And then you have a 4th case, 2986, when a capias was issued after you allegedly didn't appear. Now, each one of those cases, they set the bond at no bond. Did you already have a lawyer representing you on any of those cases?
No, sir.
Do you need the public defender's office appointed to represent you?
Yes, sir.
All right, they'll be able to go in front of the judge or judges assigned to the case to try to get you bonds again. Do you understand?
Yes, sir.
All right, thank you. Michael Adam Davis.
Medical, Your Honor.
All right, no further action than what was done before. Reset it tomorrow, see if he's able to attend. Hi, your name, please?
Barbara Claxton.
Thank you. You're here today on allegation that you committed a criminal mischief. It's a type of case that the state sometimes is able to make a plea offer and sometimes they're not able to make a plea offer. I'm going to, before we find out whether they can make a plea offer to you, we'll find out if you qualify for pretrial release or not. Does not? Okay. So state, are you able to make a plea offer? Doesn't mean you have to take the plea offer, but let's see if the state's willing to make one.
There's no offer at this time, Your Honor.
On the move-ups, I don't have those sheets readily available. Does she have any prior criminal history?
Yeah, she has 6 misdemeanor convictions, 9 FTAs, 8 unknowns. Her convictions consist of dwellers, several trespassing, resisting officer with violence, loitering. Loitering was her last conviction in 2017. Her history consists of other resisted violence, petty theft, several trespasses, and attempted burglary.
So you do qualify for the public defender, so they'll represent you, and there is probable cause for the offense, so the bond is $500 and don't return to the scene of the offense. Do you understand?
No, I didn't hear.
If you can speak a little bit louder.
I didn't hear what you said last.
Oh, yes, okay. So you have a bond of $500, and then once you post the bond, don't go back to the location of the offense.
Okay, what thing? I've been
Wait,
trying.
hold on, before you say something, first say it to your lawyer to make sure you don't say something that'll hurt your case. Oh, so the charge is criminal mischief, which means damaging someone
Not
else's
guilty
property?
is what was done. I should be sued. That where is my lawyer to sue at the file against what have they done to my family, sought to disappear me, done to me, right? You put me in several codes and call it
What's it?
suicide, right? This is not a
Okay,
jail,
does she
right?
qualify for mental
They
health
should have
pretrial
been
release or no?
arrested for those on the police. What else is
No?
going on?
All right. So today, you have a bond amount, your lawyer can look into trying to
Well,
lower.
I would post it at a drop of a dime, but you got my money and expect me to post bond, right? So they gave my check to my son and legally detained me. He's a representative paying against his will. He's 38 years old, and my son knows better. You're messing with him and me, right?
I
My
understand.
son is being controlled by a family from the police in New York. Then they gave him my check, right? And it's good to see what I do with that money. They've got the clothes off my back, the roof over my head. They said I killed myself. They have me sleeping outside, saying that I'm homeless, but I'm not. It wasn't suicide. My neighbors across the street were paying their escrow. They disappeared their all records, right? My whole family was cursed. I've been in this country since 1968. I don't know what this is about, right? But put me in a coma. I'm the last one that should be arrested. They have me living on the sidewalk for 9 years. Because as soon as I got out of my bed that morning, they put prostitutes where I should be in my fucking home, all right?
There you go, Ms. Sherman. Here's your papers.
Jail is the last place.
gotta
These
go
people
that
are out in the car.
This way.
They'll screen her for mental health pretrial release then. It may work. All right, thank you. Hi, are you Daniel Thomas? Are you Ms. Thomas?
Yes.
All right, good morning. Well, actually, it's good afternoon now. You're here because a judge signed a warrant for violations of pretrial release and set the bond at no bond. Your lawyer can try to go in front of the judge assigned to the case to try to get you a bond. You qualify for the public defender's office, so they'll represent you on the case to try to, do you understand?
So this is for the pretrial relief?
Yeah, the judge, looks like it was Judge
Barber?
Barber signed it back on August 2nd.
Okay.
All right.
I have a question.
We'll say it first to your lawyer to make sure you don't say anything that'll hurt your case. Already had it. All right.
You seen Amber? Okay, can you tell Darren Chambers to come see me? I haven't talked to him.
Shanice Green? Hi, Ms. Green, you're, let's see if anyone in the audience is here. No, you were originally charged with aggravated battery with a deadly weapon and a battery on a person over 65. I didn't see any evidence of the person's age in the report, so there's not PC for count number 2. So if you're still here in jail tomorrow, you'll see the judge with regard to count number 2 only. But there is probable cause for count number 1. So, and in both counts, I'll give you conditions of release today. Can you afford a lawyer or do you need the public defender? Actually, you qualify for the PD, so they'll represent you. I have to order that you have no contact with the listed victim. Before coming out here, they should have given you a no contact order to review. If you've read it and understood it and don't have any questions about it, go ahead and sign that no contact order. Thank you. All right, so no contact with the listed victim. You have to maintain a separate residence from the listed victim. Don't possess any weapons or firearms, and you're not allowed to return to where the victim resides. On count number 1, let's see. Your bond is going to be $1,000. The bond on count number 2 is $100. If you're still here in custody tomorrow, we'll see you on count number 2 only, but the conditions of the no contact, et cetera, are on both counts. So you can bond out if you want to, but if you're still here, they'll just address count number 2, whether it should be 100 or 0. I'm sorry, 100 or ROR. Make sense? All right, thank you.
And what is the bond on count 1? I apologize.
Charles Parsons, is that you, sir?
Yes, sir. Yes, sir.
All right, so I don't see anyone in the audience. There's probable cause to believe that you committed the offenses of aggravated battery with a deadly weapon and battery on a family or household member. That phrase is defined by law. So that form in front of you goes over, actually, now it's in front of you. That form right there is a no contact provisions. You should have, before you came out here, had an opportunity to read and understand it. Did you read and understand everything on it?
Yes.
Okay, so If that's true, go ahead and sign that form, and then I'll take it. It'll be a court order of no contact with the listed victim. All right, so just to be clear, no contact means no good or bad, no direct or indirect. Sending $1 million, sending flowers, it's still a violation of the no contact order. Make sense? You shake your head yes, but I just have to make sure people answer
Yes.
so it's captured on the microphone. You have to maintain a separate residence from the victim, don't possess any weapons or firearms, don't return to the victim's residence. You qualify for pretrial release, so you'll be on pretrial release on both counts with those conditions. You violate those conditions, it'll cause you to be, any of those conditions, it'll cause you to be right back in jail. You understand?
Yes.
All right, thank you.
Your Honor, has to provide a verifiable address before he can be released.
So,
He has to provide a verifiable alternate address before he can be released.
all right, did you understand, do you have another place to live?
For temporarily, yeah. I mean, I could find somewhere my brother or something, probably.
I think I saw that on here. Well, maybe that's a different case. Anyway, if you don't, the problem is if you don't provide that information, then you're gonna then they won't release, well, does that apply whether you post bond or straight pretrial release? Okay. So to keep you from being stuck in jail too long, in the event that you don't qualify for straight pretrial release, the bond will be $1,000 on count number 1 and $100 on count 2. If you provide that address, you won't have to post any, if you provide a valid address that satisfies pretrial release, then you won't have to post money to get out of jail. But I also don't want you to be stuck in jail.
Yeah.
If you can't find the address, then you can post the bond, but then you'll be on pretrial release, and then you don't have to provide that information to them. They'll explain more of that to you. If you get the address to them, don't have to post money to get out of jail. Don't get the address, you'll have an opportunity to post the bond instead of being stuck in jail. Does that make sense?
Yeah, kinda, I get it a little bit, yeah.
Right. Oh, very good, all right. All right, thank you, sir. Your name, please? Bridget Ferry, is that you, ma'am?
Yes.
All right, thank you. All right, so on this case here, you were arrested for aggravated battery with a deadly weapon. There's probable cause to believe the offense occurred. So there are conditions I'm required to order when I don't have the victim present. And so one of them is no contact. Have you had a chance to read and understand that no contact order before you came in here?
Yes, sir.
Okay, if that's true and you understand it, go ahead and sign that. Let's see. Can you afford a lawyer, or do you need me to appoint the public defender to represent you?
I'm sorry.
Are you able to hire, the clerk reviewed your affidavit requesting the public defender, and it looks like, based upon how you filled it out, that you don't qualify for the public defender, but it looks like it's borderline. Do you believe that you can afford to hire your own attorney, or do you need me to appoint the attorneys at the public defender's office?
I would like for you to appoint one for me,
All right,
please.
I'll appoint their officer to represent you. The gentleman to your left is one of their attorneys. So it's no contact with the victim. You're not allowed to return to the victim's residence, not allowed to possess any weapons or firearms, including any knives, and you have to maintain a separate residence. You, is this one of those that something disqualified her? Was it just the knives, or was it something else?
She wasn't able to verify any further information.
Okay, so it's gonna be $1,000 bond or pretrial release if you qualify. They'll meet with you. If you're able to provide the information they need, then you won't have to post any money to get out of jail. Otherwise, we don't want people to be stuck in jail just because you don't qualify for a straight pretrial release. Under that circumstance, you can post $1,000 bond, and then you'd be on a non-straight pretrial release. Either way, it's all those conditions that I mentioned. But they'll meet with you later today to try to get that information, okay?
Yes,
All
sir.
right, thank you. Damian Rivera is gonna be the next case. Are you Damian Rivera?
Yes, sir.
All right. All right, so you qualify for the public defender's office. They'll be appointed to represent you. And before I talk specifically to you that's in the witness box, I'm talking to anyone in the audience. The statute requires me to order no contact with the listed victim unless I hear from the victim and I'm convinced that it should be something other than no contact. If I give something other than no contact, the listed victim is considered less protected, because if it's no contact, a defendant shouldn't be around a specific victim and there shouldn't be any further altercations. If I do something like no hostile contact, that means you believe that if the defendant was around you, that we wouldn't be putting you at jeopardy, and that you believe he would abide by restrictions such as don't yell your voice, don't raise your voice at me, don't touch me, don't drink when you're around me, those kind of restrictions. Sometimes people want me to order contacts such as only texting or phone calls, or sometimes people want me to order a contact that just involves transferring a child in common back and forth. If a victim says they want it to be no contact, it will be no contact. If a victim says they want something other than no contact, I'll consider it, but no promises. I want to make sure that I've heard everything before I make a decision. All right, with that in mind, lady in the witness row, can you raise your hand the best you can?
My right hand?
Yeah, there you go. Do you swear or affirm the information you're about to tell us is true and correct?
Yes.
All right, thank you. Put your hand down. Your name, please?
Claudia Cabrera?
All right, you are the listed victim in this case here. Are you asking me for your protection that I order him to have absolutely no contact with you? Or do you want me to allow him to have some type of contact with you?
I feel safe around him. I'm not asking for any type of restriction.
All right. Do you believe that if he's around you that I'm putting your life in jeopardy?
Absolutely not.
Do you believe that if for some reason he were to violate the no hostile contact condition, do you think that, would you be afraid to call the police or the state attorney's office and let them know there's a violation?
If for some reason something like that was to happen, I would, yeah. But I don't feel like that will ever happen.
How long have you known him?
13 years.
All right.
And this is the only time something like that's ever happened. I feel like I instigated it, you know, so I don't feel not safe around him.
All right. In that case, I'll order that there be the no hostile contact. Do you want me to order that he lives somewhere else away from you, or do you not want me to make that restriction?
No, no restrictions at all, please.
All right. Sir, there's probable cause to believe the offense occurred.
Your Honor, don't mean to interrupt, but I do have a probable cause as to that.
Well, it's probable cause for at least a battery, so there's no doubt about that.
I agree with that, Judge.
So, all right, so, and you qualify for pretrial release, so you don't have to post any money to get out of jail. And in fact, if I remember right, this is a report which says, he specifically says it was only a battery. Anyway, so you don't have to post any money to get out of jail, but if you violate any of those conditions that I mentioned, it'll cause you to be right back in custody. I see the state standing? Yes, sir.
Yes, Your Honor, and just for the record, the state is requesting that the no contact order do remain in
All right,
place.
I appreciate that, thank you, but it's the no hostile contact. If you violate that condition, you'll end up right back in custody. I'm not requiring you to have any contact. You can have zero contact, you can never talk to her again if that's what you want to do. But if you're okay being around her and she's okay with you being around her, then it's perfectly fine as long as you abide by the restrictions on contact, such as don't raise your voice at me, etc. You understand? All right, thank you.
And Judge, just to be clear, was probable cause found as aggravation or just battery?
Well, for me, I just find there's probable cause to believe a crime occurred, but I'll specifically say in this case battery. But that doesn't prevent the state from filing more serious charges or no charges at all. That's fine. Victor Santiago Torres, is that you, sir?
Yes, that's correct.
All right. There's an individual in the witness box. Raise your right hand the best you can. Do you swear or affirm the information you're about to tell us is true and correct?
Yes.
All right, you can put your hand down and tell us your name, please.
My name is Maria Garcia.
All right, you're the listed victim in this case where there's charges were battery by strangulation, false imprisonment, grand theft, and battery. So you heard me explain the difference between no contact and no hostile contact and how you're less protected if I allow there to be any type of contact. Did you hear all of that?
Yes, sir.
All right. In this case, for your protection, are you asking me that I order him to have absolutely no contact with you?
No.
Do you want him to only be able to have like telephone or text contact with you? Or are you asking me to allow him to as much contact with you as you allow so long as it doesn't otherwise violate the law?
Yes, the last option.
The last one. Am I putting you in your life or your safety in jeopardy by allowing him to have contact with you?
No, this was the first time this ever happened and I instigated it.
All right. if for some reason, something like this were to happen, again, would you be afraid to contact law enforcement or pretrial release or the state?
If this were to ever happen again, I would contact police.
There's a statement in the police report that I didn't completely understand. It said you didn't think he should be, something about the driving in the physical state he was in. Did you think he might have been under the influence of alcohol or drugs? The reason why I ask you that is, if that's the case, I can make one of the conditions that he's not allowed to possess any alcohol or drugs, and that he be subject to tests just to make sure of that.
Yes.
Okay. Which one, or both?
Alcohol.
Okay. So, all right, so he qualifies for pretrial release, which means he doesn't have to post any money to get out of jail, but no hostile contact, don't possess any alcohol, not allowed to possess or consume any drugs that are not lawfully prescribed to you. If you violate any of those conditions, it'll cause you to be right back in custody. Do you understand?
I understand that, Judge.
All right, so do you, and State, are you rising to object to the contact provision?
Yes, Your Honor. State is requesting a no contact order remaining.
All right, I appreciate that. It'll stay the no hosile contact. All right,
And
thank
Your Honor,
you.
I do want to put on the record that I don't find probable cause in the affidavit for anything domestic. They didn't live with each other. I think they're just dating.
All right, thank you. Sir, your name, please.
Pedro Acosta.
All right. In this case here, there's probable cause to believe that a battery occurred on a family or household member. And if I have to order no contact between you, I have to order that you have no contact with the listed victim. Prior to coming out here, you should have had an opportunity to review a no contact order. Did you have a chance to read and understand that document there in front of you?
Yes, I read it now, but I don't have nothing else to where I live and anything like that. So I wanted to talk to you and help me with that one because we lived together for almost 40 years. I'm sorry first with my wife when you guys, but I
Well, hold on
wanted
one
to
second. So by law, I'm required to order the no contact, to maintain a separate residence, don't possess any weapons or firearms, no return, except for one time with law enforcement, which means you'd contact law enforcement, they'd arrange for them to go with you to the house.
Yes.
Your attorney can always schedule a hearing in front of the judge assigned to the case and try to modify the conditions to allow that. And there's a note here that says that she was gonna try to appear for court. I could pass the case and come back to it to see if she's just running late. And because maybe she wants there to be some type of contact.
I don't think so. She have a problem with contact with me. As we live in for 40 years, that's only one mistake I make. That was
Well,
intoxicated.
don't talk about the facts of the case, but let me do this. Let me just put him at the end, and if maybe she'll show up and she might want there to be contact, and I'll take it into consideration.
Okay.
But
thank
without
you.
her being here, I would have to order the no contact, which
Okay.
could be changed later by a judge. So let me just, because there's a note that she was gonna attend, let me just come back to the case.
At the end of the DD section or the end of the whole document?
Let's put him at the end of the whole docket. Your name, please?
Jennifer Arvelo.
All right, thank you. In this case here, can you afford a lawyer? Do you need the services of the public defender? You're here today for an allegation that you committed a battery on a family or household member, and there is probable cause. Do you need a lawyer to represent you?
Yes.
All right, so appoint the office of the public defender. All right, let's see. I'll ask that why didn't she qualify for the pretrial release?
I wasn't able to verify any of the information provided.
All right, got it. So you might ultimately qualify for pretrial release. Maybe, I don't know. If you do ultimately qualify, then you won't have to post any money to get out of jail. Otherwise, then you're required to have a post a bond and then be on pretrial release. So without the victim being here, I have to order that you have no contact with the listed victim. There's a document in front of you called a no contact order that you should have had an opportunity to read and understand that describes what no contact means. Did you read it and understand it?
I did, but I have a child with this person, and he's a 3-month-old. He stays with me.
Let me see if this is the case where I read about DCF.
Yes.
the initial appearance court isn't where the court gets to start altering time-sharing arrangements. I can tell you that if the two of you were not married and the child was born, then unless there was a paternity action or some other court order, then the father would have no legal rights. But if, in this case here, it appears that he's at least the father, which means that at least the child's not with some stranger, you would have to go to the domestic court to have the child returned to you. Because it's still no contact. Your lawyer can schedule a hearing in front of the judge assigned to the case to try to modify this. The only other thing I could do is allow a third-party intermediary to try to contact the victim with regard to time sharing, child custody, and child support. But the way that would work is this. Let's say you picked, I'm gonna just make up a random name, but let's hope.
May I
that-
say something, Your Honor?
Well, hold on a moment, I'll let you talk. Let's say that you knew Barack Obama. Maybe you do, maybe you don't, but I'm saying, let's say you knew him, you would be able to contact Barack Obama and say, hey, can you contact Mr. Phillips and ask him to give the child to Barack Obama, and then Barack Obama give the child to you. But that's very different than me ordering Mr. Phillips to return the child, in my example, to Barack Obama to give to you. See how one is just to relay a message, non-hostile messages for the purposes of time sharing, child support, and well, that's it. Time sharing, child support. You want to say something? First say it to your lawyer, and then maybe it's something I can consider.
And Judge, just to be clear, are you requesting that a third party be named so that she could?
No.
So just any third party will be able to
communicate a message about time sharing and child support and child exchange. So once again, so my example, if Barack, maybe I shouldn't have picked Barack Obama, I'll just pick Tony. Let's say there's some guy named Tony that you're comfortable with. Tony would contact Mr. Phillips. Hi, I'm calling to relay a message only about child custody, child support, or child exchange. Let's say Mr. Phillips says, I'm not talking to you, Tony, and hangs up the phone. Well, that's the end of it. Family court is where you address issues with because I don't have the ability to order Mr. Phillips to do anything, because Mr. Phillips would have to have notice and opportunity to be heard before I can order him to do anything. But you can go through either through DCF or family court and get this stuff addressed.
Okay.
I know I completely understand how, from your perspective, it might feel frustrating, but it's all I could do. All right, so let's review. No contact except through a third person for non-hostile contact on child custody, child support, child exchange. Otherwise, it's no contact at all. Not allowed to possess any weapons or firearms, not allowed to go to the victim's residence, and you have to maintain a separate residence from the victim. The bond is going to be $500 or pretrial release if you qualify. If you post the bond, you're still on pretrial release. It's just not straight pretrial release. Child custody, child support, child exchange.
So I have to pay this?
No, they're gonna try to get you at least on pretrial release if they do.
All right, your name, please?
James Beck.
500 in pretrial release or straight pretrial release if she qualifies. All right, raise your right hand the best you can. You swear or affirm the information you're about to tell us is both true and correct?
Yes.
All right, thank you. You can put your hand down. Tell us your name, please.
Jennifer Kathleen Beck.
You're the listed victim in this case where Mr. Beck, who's present here today, is charged with battery and there is probable cause to believe the offense occurred. You heard me explain the difference between no contact and no hostile contact and how you're less protected under the no hostile contact?
Yes, Your Honor.
How long have you known Mr. Beck?
About 8 years.
Are you, based upon the length of time you've known him, are you asking me for your protection to order that he have no contact with you?
Yes, Your Honor.
Okay. So, now, sir, in front of you there is a document that lists what no contact means. It's no good or bad contact, no direct or indirect contact. And this condition remains unless and until the case is over or a court changes it.
Yes, Your Honor.
Sometimes what happens is victims change their mind at some point in time, and then they call the defendant. But don't do that because he's not allowed to contact you. So it's not really fair for you to text him and say, hey, I've been thinking about it, I want to change my mind. You can contact his lawyer's office, or you can contact the state attorney's office if there wants to be a change. Does that make sense?
Yes, Your Honor.
Sometimes, just so you understand, also, believe me, I'm not putting any pressure on you at all. I just want to make sure I understand. So no contact, and you don't even want there to be texting or phone calls, just zero, right?
Yes, Your Honor.
Okay. So did you read and understand that no contact form there, sir?
Yes, sir.
All right, so go ahead and sign that if you read it and understood it, and then I'll order the no contact. All right, so I'll order that you maintain a separate residence, that you don't possess any weapons or firearms, and you don't go to the victim's residence. Do you have belongings at her place?
Yes, sir.
All right, so you're allowed to return one time with law enforcement to collect some belongings, but let me just explain to you what that means. You'll first contact law enforcement for whoever's got jurisdiction over your property. It looks like that's gonna be OPD. I promise you won't be the first person that's ever contacted them to say, hey, I wanna be able to return one time. They'll tell you the procedure. The procedure is never go directly to the house. If you go to the house, when the police get there, they're gonna arrest you. The police will tell you to meet them somewhere other than the house, and they'll escort you to the house for you to collect the belongings. Make sure you understand what it is that you're allowed to, the parameters before you go, because some people have like rented like a truck, and they show up there and the police are like, I'm sure, they show up at the place the police tell them to, the police go with them to the house, and the police says, we're only gonna let you take some clothes and toiletry. So the renting the truck was a waste of money. So make sure you understand what the parameters are. If you disagree with what the police say, then you're just gonna say, thank you, you're gonna contact your lawyer, and they can always schedule a hearing in front of the judge assigned to the case to become more detailed with the parameters of what it is allowed to be taken. Make sense?
Yes, sir.
All right.
Can a third party be with me, sir? Because I need somebody to drive me. I don't have access to a vehicle.
Can when you're with the police officer, you mean?
A third party's got to drive me home or to meet the police officer.
Sure, that's fine.
Okay.
Let's see, because the police officer's gonna be there the whole time. All right, so do you have any reason to believe that he's not going to follow through with the no contact order?
Yes.
You think I'm sorry, maybe I asked the question. Will he follow the court order, or are you afraid?
I'm afraid that he will not.
Okay. If he does violate the court order, then you simply would contact law enforcement, the state attorney's office, or the pretrial release office to let them know that there's a violation, okay? He qualifies for not having to post a bond to get out of jail, but he still has to follow all those conditions that I mentioned, okay? And you can contact the state attorney's office as soon as you want to, and so they can meet with them to discuss the case.
All right, thank
Now,
you.
one last thing just to avoid any confusion. Even though there's a no contact order, and as you heard me probably explain to other people, he's not allowed to relay a message through other people, his lawyer is still allowed to defend you. So if his lawyer calls you on the telephone and says, hi, I'm, Tom Smith with the Public Defender's Office, and I want to talk to you about the case, and that would not be a violation of the no contact order. And the same thing, obviously, if the state might call you at some point in time. Feel free to say, let me have your number, I'm gonna call you back, so you can verify they really are with the state or really are with the defense attorney. Okay.
Okay, thank you.
Yes, ma'am. Yes, right. All right, thank you all.
And can I say one thing?
Wait, hold up, what's that?
Can I say one thing? That no woman instigates to be touched. I did not instigate it, and no woman or man instigates to be touched or hurt at all.
All right, thank you very much.
Thank you.
All right, your name, sir?
Russell Baccio.
All right, thank you. Sir, if you raise your right hand the best you can, do you swear or affirm the information you're about to tell us is true and correct?
Yes, sir.
All right, thank you. You can put your hand down. Tell us your name, please.
Lloyd Edward Poole, Jr.
All right, thank you. You're the listed victim in the particular case. I'll be with you in just a moment.
Thank you.
Sir, you're taken into custody for the offense of battery on a family or household member. There is probable cause to believe the offense occurred, and now we're about to set conditions of release. All right, turning back to you, sir. You heard me explain the difference between no contact and no hostile contact, and how you're less protected if I allow there to be any type of contact. But how long have you known this gentleman?
We've been together 13 years.
Okay, are you asking me to order that he have no contact with you, or do you want me to consider allowing there to be some type of contact?
I would like complete contact. We have a mother. His mother is at home. She's disabled. It takes both of us to help take care of her. And I don't feel threatened by him. This is an isolated incident. I need him there to help with the situations.
All right, so do you think that if he were to do something like this again, would you be afraid to contact law enforcement, the state attorney's office, or the police? Or
Absolutely not.
For Charlie, sorry. And let's see. All right, he does qualify for pretrial release without having to post any money to get out of jail. Is this one that the state is objecting also?
Yes, Your Honor.
All right, thank you. Let me just explain to you what no hostile contact means. He says complete contact, but what I do is I order something called no hostile contact. He's heard me explain it to other people, but you didn't have the benefit. It means you cannot have any more contact with him than he allows you to have, and it cannot otherwise violate the law. Like he can't say to you, hit my hand with a hammer. That would still violate the law even if he said it. If he says to you, don't raise your voice at me, then you can't raise your voice at him. He cannot make you have contact with him. If you don't want to ever see him again and you never go back, that's your business. But if he's okay with you being around him and you want to be around him, that's perfectly fine, so long as so it's not hostile. Make sense?
Yes, sir.
All right. You're not allowed to possess any weapons or firearms. You'll be released on pretrial release without having to post any money to get out of jail. Just make sure you abide by those conditions. Now, at this point in time, the clerk's office has determined you don't qualify for the public defender.
Okay.
But at your next court date, if the state does file charges against you, then you can ask for the public defender if you can't afford a lawyer. Make sense?
Yes, sir.
All right.
Oh, I was going to say, you answered my question though, because I believe he's already been terminated from his employment.
All right, let me see if they took that into account here. All right.
Yeah, it happened today.
And they already fired him?
Yes.
All right, so was that your source of income?
Yes, sir.
All right, I'll appoint the public defender to represent you. All right, thank you. Hopefully they'll rehire you once they see you're back out of jail. Your name, sir?
Nicholas Pyle.
All right. On this case here, there's probable cause to believe you committed a battery on a family or household member, as that phrase is defined by law. I am required to order that you have no contact with the listed victim. Prior to coming out here, you should have had an opportunity to review a no contact order that explains what no contact means. Did you have a chance to read it and understand it?
Excuse me. Yes, I did, sir. Can I ask a question?
Yeah, first say it to the assistant public defender. I'll point them to represent you.
I didn't read my rights and nothing, just because.
You can proceed, Your Honor.
All right, thank you. So if you've read and understood the no contact, go ahead and fill that out, and then I'll take it.
And how long is before?
Thank you. All right, so no contact with the victim, maintain a separate residence from the victim, don't possess any weapons or firearms. And don't return to the victim's residence except for one time with law enforcement to collect belongings. You'd contact law enforcement. There's a procedure, follow the procedure. If you go directly to the house, when the police get there, they're just gonna arrest you. They'll meet you somewhere other than the house and accompany you to go there to collect belongings. Did you hear me explain that process to the person that was just in front of you?
No, I did not.
Okay. So all these law enforcement agencies, they have a procedure.
Okay.
And so when you call them and tell them that you're allowed to return one time, they'll tell you whatever that procedure is. They might meet you like 2 blocks away from the house and then go with you to the house to make sure everything goes smoothly
Okay.
in collecting your belongings. Don't rent like a pickup truck or something like that before you go, because they might not let you spend all day collecting whatever items.
What if it's my residence?
Well, I don't have the ability to evict other people. All I have the ability to do is, I can put on the paperwork that if pretrial release verifies the other person has moved, you can return back there. But unless they do that, then I don't have the ability to just say you're allowed to go back there and have the other person not live there.
I got a question, sir. What if the other person agree with that? It was just mainly just a heated argument. It wasn't really a physical altercation or nothing like that.
The victim can always meet with the state.
Okay.
They can always ask the state to not proceed, and the state can take that into consideration, and they can
Okay.
choose whether to proceed or not proceed. You have now the public defender's office representing you. Sometimes they'll contact the victim on your behalf, and they'll see what they need to do to either have something scheduled in court to try to modify the conditions of release. But today, all I can do is order what I ordered, because I don't hear from the victim. If the victim eventually comes to
Because
court.
we have 2 kids and we both live in this place by ourselves. And her family lives in Fort Lauderdale, and I just moved them from Fort Lauderdale. So I felt like she just couldn't come because I got a 7-year-old and I have a 5-year-old.
There's a note here that says that arranging for child supervision might prevent her from being able to come to court.
Yeah, because she have the kids. We have no babysitter, nothing like that. It's just us parenting. We just had a heated argument over a TV remote. So this is going way beyond the Call of Duty. I did not punch, slap, hit her in no form or fashion. I just needed her to leave for a while because she was getting.
I don't want you.
All I can tell you is this might end up being just a temporary order until your lawyer gets in front of a judge. to
I have
modify
2
it.
babies, man.
Are we appointed on this case?
Yes, sir. Yeah, so it's the same as before.
I have 2 little babies. Okay.
He qualifies for straight pretrial release, right?
Okay. I take care of everybody.
All right, so you don't have to post any money to get out of jail. It looks like you're planning to live with your brother.
Yeah, my twin brother lives across the street.
Yeah. But don't, all right, you don't need to tell it out loud here, but do you know the
I
address?
don't really know the address, but if you could contact him, because we both just moved from Fort Lauderdale.
But
Everything is
do you
new.
have his phone up? What's that? Oh, yeah, she'll go meet with you.
Okay.
So just to make sure that you're not in jail just because you don't qualify for pretrial release, it'll be a $500 bond and pretrial release, or straight pretrial release if you qualify. If there's some address issue, then you can choose to post the bond and then be on pretrial release with these conditions. But if you're able to resolve this address issue by your brother's address,
Mhm.
then you won't have to post any money to get out of jail. But if you break any of these restrictions that I put on you, it's going to cause you to be right back in jail.
This number Monday. Okay, they're gonna get you released today. No, if they can verify the address, call this number tomorrow. We'll start working on it.
So they released me today.
They should.
Benjamin Reddick. All right, you qualify for the public defender's office. They'll be appointed to represent you. There's probable cause to believe that 2 offenses occurred. One's a battery on a family or household member. The other one is just a simple battery. Let's see. I have to reset count 1. Let me see my note here. Hold on. Right. The count with regard to the girlfriend, that one is I'm not able to make a finding of PC on that one right now. you're still here in jail tomorrow, we'll readdress the conditions on that case. But you do qualify for straight pretrial release, which means you'll be able to get out of jail without having to post any money. But I am required today to say you have no contact with either of the listed victims. No contact is described in that form there, which you should have had an opportunity to read and understand before coming in here. Did you read and understand that form already?
Yes, sir.
So even if the victim tries to contact you, if you talk to the victim, it's a violation of the no contact order until it's modified in court. So no contact with the listed victim. If the listed victims, maintain a separate residence from the victims, don't possess any weapons or firearms, and don't go to where either of the victims reside. If, I don't know why you'd still be here in custody tomorrow because you qualify for straight pretrial release, but if you're still here, the court will address probable cause with regard to victim Ariana Butcher. It's, it will have to be, it must be the count 2 that's called designated as domestic violence.
And Judge, I know there's some property that he'd need to get if we can allow one visit with escort.
So the visit to which place? Because it looks like there was a hotel, and then at one point in time they were living together. I just want to make sure I know where the one place
It's
is.
the address, not the hotel.
Okay, so return one time with law enforcement to collect belongings. All right, thank you. Todd Schulman is the next case. We'll be with him in a moment. Ready, Mr. Schulman?
Yes, Your Honor.
All right. Raise your right hand the best you can. Do you swear affirm the information you're about to tell us is true and correct?
Yes.
All right, thank you. If you get a little bit closer to that microphone and tell us your name, please.
Savannah Schulman.
All right, you're the listed victim in the case. We'll talk about contact in just a moment. Sir, in your case here, there's probable cause to believe that you committed a battery on a family or household member that phrase is defined by law. You qualify for the public defender. They'll be appointed to represent you. We're about to set conditions of release. All right, now back to you. So you had an opportunity to hear me explain the difference between no contact and no hostile contact and how you're less protected under no hostile contact than you are on no contact. You understood that so far? How long have you known him?
About 10 years.
For some reason, there must not be a speaker above me, so sometimes it's hard for me to hear. Can you just get a little bit closer to that microphone?
At about 10 years.
10 years, all right. Based upon how long you've known him, are you asking me for your protection to order that he have absolutely no contact with you, or do you want him to have some type of contact with you?
I would like for him to have contact.
Okay. Sometimes people tell me they only want it to be phone or text message. Other times people want me to give as much as I would allow. Which,
I would like full contact as much as you allow.
all right, so let me explain to him what that means. And this one, the state, are you objecting to this one?
Yes, Your Honor. The state is requesting a no contact remaining order.
Okay, thank you. All right, so if I were to order the no hostile contact, this is what it would mean. It'd mean no more contact with her than she allows. So for example, if she says, don't raise your voice at me, then you couldn't raise your voice at her. If she says, don't live at the house, you wouldn't be allowed to live at the house. If she says, don't be around me after you've had anything to drink, then you wouldn't be allowed to be around her after you've had anything to drink. You don't have to have any contact with her. You could stay away from her, but if you want to be around her and she's okay, that's perfectly fine if I order the no hostile contact. Do you understand that so far?
Yes, Your Honor.
Okay. Do you, ma'am, back to you. Do you think that if he violated the conditions, I need to prevent a double negative. If he violates the condition, will you feel comfortable calling law enforcement?
Yes.
So and do you want me to order that he lives somewhere other than you, or just?
No.
All right. So remember, if at some point in time you change your mind, if you tell him, he'd have to move somewhere else if I do the no hostile contact.
I
Got it?
understand.
All right. So, sir, you qualify for a pretrial release. You won't have to post any money to get out of jail. It'd be no hostile contact with the listed victim. Don't possess any weapons or firearms. If you violate the no hostile contact condition, it's going to cause you to be right back in custody. Do you understand?
Yes, Your Honor.
All right. All right, thank you all.
And Your Honor, was the PD appointed on the case?
Yes, sir.
Okay, do I just take this?
Austin Williams is the next case. Are you Mr. Williams?
Yes, Your Honor.
All right, I don't see the victim here, so I am required to order that you have no contact with her. You should have had an opportunity to read and understand the no contact order before coming out here. If so, if you've read it and understood it, go ahead and sign that for me, please.
I have not had an opportunity to read it.
All right, we'll let you, we're going to pass you and give you a chance to read. You have your reading glasses with you?
Yes.
Okay,
Yes, Your Honor.
so what we'll have you do is we'll let you lean against the wall there and read that while we go on to other people's cases.
Yes, sir.
All right, so your name, please?
Ricardo Belzer.
You're taken in custody for a warrant for your arrest that had 8 charges. The charges were trafficking in heroin over 28 grams, trafficking in meth over 28 grams, trafficking in heroin over 28 grams, trafficking in meth over 28 grams, another trafficking in meth over 200 grams, conspiracy to traffic in meth over 200 grams, and trafficking in heroin over 20 grams, and unlawful use of a two-way communication device. You qualify for the Public Defender's Office. They'll be appointed to represent you. Do you understand so far?
Yes, sir.
I'm the one who signed the warrant, and I set the bond at no bond to be set today, so here I am about to set the bond. Based upon your prior criminal history and the facts of the case, the bond is going to be $200,000 on count 1 and $150 on each of the remaining counts. If you ultimately can't afford to post the bond, you can go in front of the judge assigned to the case to address trying to have the bond reduced, but you have to first try and be able to explain to the judge how you tried and were unable to do it. You understand? You want to say something? First say it to your attorney to your left.
I just,
Yes, ma'am.
We can proceed, Judge.
All right, thank you. Well, that's all for that case. The next case is Michelle Campbell. You have 2 different cases here. You have one case in which it's a possession of methamphetamine where there is probable cause to believe the offense occurred. And then you have a case where you're picked up on a warrant where it's trafficking in amphetamines greater than 200 grams and conspiracy to traffic in amphetamines in 200 grams based upon, well, on the simple possession charge, the bond is $1,000. On the one with the arrest warrant, which originally was set at, if I remember correctly, since I'm the one who signed it, no bond to be set today. The bond on count number 1, based upon your prior criminal history and the facts of the case, are $100,000 on count 1 and $150 on count 2. If you can't afford to post the bond after trying, you can always go in front of the judge assigned to the case to try to readdress conditions of release. Do you understand?
Yes, sir.
All right, thank you.
He's ready, Your Honor. He read the paper.
All right, back to Mr. Williams. Hold on one second. Oh, yes. There it is right here. All right, Mr. Williams. So you had a chance to thoroughly read and understand everything on the no contact order?
Yes, sir.
If you read and understood it, go ahead and sign it and hand it to the corrections officer. So no contact means no good or contact, no good or bad contact, no direct or indirect. You send $1 million or flowers to the victim, you'll be in violation of the no contact order.
Yes, sir.
You have to maintain a separate residence from the victim, not allowed to possess any weapons or firearms. You're not allowed to return to the victim's residence. Now, it looks like they were reviewing you for pretrial release, but they might not have finished it yet. If I read this correctly. Is that correct? They're still in the process? So you might qualify. All right. So in this case right here, it's either $500 bond and pretrial release or straight pretrial release if you qualify. They're gonna meet with you later. It's possible that you qualify without having to post any money to get out of jail. But if for some reason, if they say you don't qualify, then you can post the $500 bond and then be on the other type of pretrial release. But it's still the same conditions,
Yes, Your Honor.
and the public defender's office will represent you. Remember, if you violate the no contact order, it'll get you right back here in jail. All right, thank you.
Yes, Your Honor.
Oh, yeah, since he might qualify for straight pretrial release. He might, after you meet with him, he might qualify for straight pretrial release, right? If so, that, okay, so we just need to change the language. 500 and PTR or straight pretrial release if he qualifies. Right, okay, yeah, so if you can pull those out, if they let us know and we'll make sure.
Bond plus $500 plus pretrial release, or pretrial release if you qualify.
Right, he's still gonna qualify, but he's still saying bond and PTR.
Right, so say if he wanna post a bond. Right. He posts a bond, he gonna still be on plus pretrial release. But if you don't wanna post a bond, it's just straight pretrial release.
If he qualifies.
The way that is written, I'm gonna have to explain that to second chair.
Oh, what do we-
And then he's gonna be like, no, it needs to be one or the other.
So how do we have to write it to make it to be?
So this, if you wanted to have bond and PTR, just say bond and PTR, but if you just wanted to have PTR if he qualifies, what portion of the bond? That's just the way.
Oh, wait, so, oh no, what you're saying is, if he doesn't, like, let's say that one gentleman who got the address, you're saying if for some reason he can't get his brother's address, he'll never qualify for PTR even as a listen on the top of bond?
If you can't verify, you will not get PTR. It has to be verified based on the back and ours.
Well, we'll leave it like this, and then it might have to be brought back in front of the IA judge to address it.
So the one that we can't get the address, just have them bring that. Okay.
All right, got it. You're Vincent DeCesio?
Yes, yes, sir.
I'm probably
Yes, Your Honor.
did I pronounce your name correct?
I like Dizio, but Dizeo is really how it's pronounced.
Be with you in just a moment. I have your paperwork right here, but there's some other paperwork that lists the person's prior criminal history that I put up more here. Got it. Three of these cases here, the Office of the Public Defender will represent you, 2019 CF 11370, 2019 MM 769, and 2019 CT 692A. On those cases, there's probable cause for the driving while license suspended with knowledge, possession of cocaine, and possession of drug paraphernalia, and your bond will be stayed on each one of those counts. You're on probation out of Lake County. I cannot appoint the public defender to represent you on a Lake County case because the Ninth Circuit doesn't include Lake County. But once you post the bonds on the Orange County cases, then Lake County will be told to come and pick you up, and they'll take you there, and then you can have a public defender represent you there if you can't afford an attorney. From your affidavit, it appears you cannot afford a lawyer, but I can only appoint them to represent you on the Orange County cases.
Your Honor, what are the bonds on those cases?
500 on the driving while license suspended. Actually, this one can't possibly be right. The possession of cocaine should be $1,000.
What was it, what was it at?
$1,000, but for, so, and then the possession of paraphernalia is $500. And the out-of-county is no bond, right?
Your Honor, thank you for that. I appreciate you. Thank you.
All right, your name, please?
Passion Homes.
All right, thank you. There's probable cause to believe the sale of cannabis. Let me see if you qualify. Let's see. Why didn't she qualify for pretrial release?
Her community ties and information cannot be verified.
All right, so in this case here, your bond, if for some reason they're able to verify your community ties later, you'll be able to release pretrial release. Otherwise, it'll be bond or $500 bond or pretrial release. If you qualify. So that language is okay then. Got it. Your name, please?
Hakeem Farouk Hudson.
All right, thank you.
Your Honor, just for your information, I do have a probable cause argument.
All right, I'm curious.
It's not a dwelling, Judge. I mean, it's definition of dwelling is a building. He was already within the building. Entering into a room isn't a separate building. I don't think they could get that jury instruction. Looking at the jury instructions, it explicitly defines it as a building. I can't find any case law to differentiate the interior rooms of a building versus the building itself. Therefore, I presume just going off the definition that's in the jury instructions and it still doesn't fit that definition.
So when a person goes behind like say the cash register at like a 7-Eleven, where they don't have a right to go and they take something, is that not still burglary?
Your Honor, I think there's definitions of case laws about when going into a structure or a portion of that structure where persons aren't allowed. I think that there is case law for that. However, that would be burglary of a structure, not burglary of a dwelling.
When I do my initial appearances, I feel like my responsibility is if they arrest the person for 4 counts, if the question is there probable cause for 4 separate counts? There's at least probable cause to believe a crime occurred, whether it's burglary of a dwelling, whether it's burglary of a structure. So there's probable cause for an offense. It's certainly not enough here in my mind to hold them at no bond. So I'm gonna give conditions of release of $2,500 bond and no contact with the victim.
Your Honor,
It's gonna be the same, the other person who's,
both live there.
Your Honor, Mr. Hudson and the alleged victim in this case both live in this group home. Not quite sure how that would work out.
Can't remember if the other person is on our docket for today.
What was the name?
McGriff is the last name?
Yeah, I don't think I saw it, Judge.
I have,
I'm not sure if there was something filed, stating it was filed with the state attorney's office, or if he was arrested or not.
Oh, right, he wasn't arrested. Still required to order no contact, there's just no way around it. Oh, yeah, sorry. So the public defender will represent you. I just don't, there's no legal way around for me around it. It's no contact with the listed victim. I'll put on there, return one time with law enforcement to collect your belongings. That'll at least allow you to get some of your stuff. All right, your name, please?
Rockwell Graham Jansen.
All right, so in your case here, you do qualify for pretrial release. The conditions are going to be, Public Defender's Office will be appointed to represent you based upon your affidavit. Probable cause to believe the offense occurred, a driving while license suspended, possession of cocaine, heroin, and paraphernalia. You won't have to post any money to get out of jail, but you'll have conditions such as don't drive without a valid driver's license and not allowed to possess any drugs that are not lawfully prescribed. You'll be subject to random tests to make sure you're not violating that court order. Do you understand?
Yep.
All right, thank you. Andrew Jordan, is that you, sir?
Yes, sir.
All right, the allegations are grand theft.
Your Honor, for the record, I have a probable cause argument.
All right, I'll listen. I'm always open-minded. I didn't see the issue, but maybe you can.
I just, in the affidavit, we're confined to the four corners of the affidavit. I don't think I saw a listed owner or whether or not that owner stated that Mr. Jordan specifically did or did not have license to operate the vehicle. Under those circumstances, there is no probable cause to make an arrest. You know, and I'm not sure if that's something that the officer knows, but just didn't put in the affidavit. That's his requirement if he wants his arrest to stay in custody or to get bonded. But if he doesn't put that down, it's similar to the battery argument over a person over 65. If you don't list their birth date, then there's no probable cause for that battery on a person over 65. If you don't list whether the owner did or did not give license to Mr. Jordan or any other criminal defendant to use that vehicle, well, then there's no probable cause whether Mr. Jordan or any other defendant could be arrested for grand theft motor vehicle.
I appreciate the argument, but here it says it was reported stolen, and there's another gentleman driving in the car that was reported stolen. For
And
probable
again,
cause purposes, I
Judge,
think that's sufficient.
And I'm sorry.
You don't need to apologize for doing your job.
Sorry for interrupting. I think I jumped too quickly. I can call my vehicle and stolen. It could get returned, or I could find it, and I just don't take that off call the cops and say, hey, I found it, everything's fine. It could still remain on their registry as stolen, and it's not. Again, it's something that the officer has to do if he wants to have probable cause found in a case where he makes an arrest. If the officer doesn't do it, then that's on the officer. Again, the state attorney's office can get 24 hours to get that information, and I'd be fine with that. Again, I just think it's the officer's duty, and he didn't do it.
I appreciate the argument. I think the language in here is sufficient. So, and the bond is gonna be $1,000. All right, thank you.
No pre-trial release?
All right, your name, sir?
Alvaro Lopez.
All right, the allegations are that you trafficked in a controlled substance, that you possessed heroin. with
Your
intent-
Honor, not to interrupt, I just want to give you information before you go through everything. I do have a probable cause argument for the trafficking and the sale and delivery.
All right, I still have to tell him what he's in jail for. So
Yes, Your Honor.
you're arrested for trafficking in a controlled substance, possession of heroin with intent to sell or deliver, possession of alprazolam, and possession of cocaine. Yes, sir, whenever you're ready.
I'm sorry?
Whenever you're ready.
Okay.
Oh, wait, hold on. And based upon your affidavit of indigency, you got the public defender. That's him.
If I may just look at the affidavit real quick, just to remind myself. I do know as for the trafficking, Your Honor, they put trafficking in of a controlled substance. The statute that they use specifically lists drugs that are not alprazolam. Alprazolam, I've looked through the statute. I've looked through all the other statutes. I can't find trafficking in alprazolam, but it's definitely not part of that statute, and it's definitely more than 4 grams if it is. The 4 grams that they're specifically talking about is morphine, heroin. That's trafficking. Again, for alprazolam, if there is a trafficking statute, it's more than 4 grams. It's probably 14 grams. And again, if you go to the statute in question, it does not mention alprazolam or anything related to alprazolam. That specific subsection. And I do know that the trafficking statute.
So I will, roll it till tomorrow with regard to count number 1. Maybe
Your Honor, if I may, I don't think there's anything that the state attorney's office is going to get from the officer that's going to change that. I request that he be released on it as of today.
I understand your request, but I have no idea what they'll find. So, all right, so roll it till tomorrow, leaving the bond as amount. So put on there, roll till tomorrow with regard to count 1. Do you know any idea if it's Amy Carter or Carly Wish that's here tomorrow? Treasurer Wish, all right. All right, so, and then in the event that there's no PC found with regard to count 1, then to address I guess the remaining conditions of release. But otherwise, it's stays at 100 grand, count 1, 150, 150, 150. But there's probable cause for counts 2, 3, and 4.
And I just want to put on the record that I don't see probable cause for sale and delivery within the affidavit. There's no mention of scales, dealer wallets, hand-to-hand transactions, anything that would indicate sale or delivery.
All right, I appreciate it, but same finding.
And Your Honor, are you leaving count 1 at 100,000?
Yes, sir.
Any way we can get a reduction in that amount based on the fact that it is a Schedule 4? Schedule 4 drugs have low risk of abuse. Schedule 4 drugs have medical use. The reason, again, it's the reason why it's a Schedule 4 drug.
It might end up being an ROR tomorrow, or maybe there's something else that maybe the officer made a mistake in what he wrote as far as the substance. So I'm just leave it as for like this until tomorrow. Thank you.
And it's 150, 150, and 150 on the others?
Yes, sir. Mr. Moore, you step on up. All right, qualify for the Public Defender's Office. They'll be appointed to represent you. There's probable cause to believe the offense occurred. The bond will remain $3,500, and you're not allowed to return to the location of the offense. Do you understand?
Yes, sir.
All right, thank you.
Your Honor, we request that, since it is a possession of cocaine offense, if we can have a bond of $1,500.
You believe he had a second case?
Oh, I'm sorry, I'm looking at the wrong sheet, it's burglary conveyance. Still requesting $1,500 on bond.
It looks like he's just released from prison recently. Let me make sure, or probation, let me see what it was.
March 26.
If this was true, he was just released from the Department of Corrections in March on theft-related charges. So I'm gonna go ahead and leave it the same, thank you. Hi, your name, please?
Richard Remus.
All right, thank you. Before I address your case, there was a Glenn Murray, did they bond out?
Yes, bonded.
Thank you. All right, sir, the public defender's office will be appointed to represent you. There is probable cause for the possession of cocaine and also the resisting without violence, and your bond's in the stay at the $1,500. Do you understand?
Yes.
All right, thank you.
Thank you.
Jose Rivera? Oh, actually, your name, please?
No, sir.
No, what's your name?
My name is Mr. Streeter.
All right, thank you. Sometimes I'll have a person's paperwork before the next, it just means they bonded out, but let me just find out. Did Jose Rivera bond out? I can't see it.
1902396.
Oh, yeah. 3926. Bonded out, all right. All right, Mr. Streeter, based upon your affidavit of indigency, wait a minute, I thought I saw it.
Your Honor, it's also my understanding that Mr. Streeter may have an attorney, or if we can inquire as to whether one's actually been hired or not.
Do you plan on hiring just so you know what these charges are, maybe they've told you, maybe they haven't told you. You had 3 separate arrest warrants that were signed. One of them was for burglary structure, grand theft, dealing in stolen property. The next one was for, and that was case number 962. Then you also had case number 961, which was burglary of a structure, grand theft. Just those 2? Just those 2, all right. 10961, right? Right. And so these offenses, one is supposedly occurred on December 3rd of 2019, so that can't be possible. Let's see. Let me look at the police report. Oh, 18. December 3rd of 2018, and the other one supposedly took place on December 15th of 2018. Do you think you've hired an attorney to represent you on the cases?
I talked to my family. They told me that they was giving me an attorney. So
Well, if you want, I can roll you 2 tomorrow, and you can have the attorney present, and if the attorney doesn't come, then you can see if you want the public defender appointed to represent you if you can't afford a lawyer. Do you want me to just roll it till tomorrow?
how's it looking now?
Well, the arrest warrant had bonds of $10,000, $50,000, $50,000. The other arrest warrant had something, yeah, $10,000 and $50,000. And if you want me to, I can roll it till tomorrow and then that attorney, if you hire one, can address the conditions of release. Otherwise, I can do it today, and then if you want, I could appoint the public defender to represent you, but if you qualify, I have no idea, because the paperwork's not filled out. Otherwise, it looks like there's a note here that says, and I don't want you to confirm it, don't say anything about it, just for information purposes, the jail believes that you've had 5 felonies, 4 misdemeanors, 3 failures to appear, one of which was in 2018, and then 10 unknown stuff. And then you might have some open cases in Orange County. Don't say anything about that. But they're saying that's your criminal histories. If you think you all are hired a lawyer and you want the lawyer to be present, then let me just reset it for tomorrow, and they can address the conditions of release. It's an arrest warrant. That means those are your bonds up until initial appearance, and when you come to initial appearance, your bonds can be higher or lower based upon everything that's presented. So it's really up to you. It's just a simple question. Roll till tomorrow to have the lawyer that you think your family's in the process of hiring, or have it today, but if we have it today, it doesn't get reset for tomorrow. So if they're in the process of hiring a lawyer and we do it today, then the lawyer's gonna be having to go in front of the judge assigned to the case. If we roll it till tomorrow, then what happens is then your initial appearance is addressed and conditions of release can be addressed. Do you wanna think about it for a moment? I can go into someone else's case.
Yeah.
Okay, just lean against that wall there, and we'll come right back to you. Shaquille Tucker?
Yes.
Right. So in your case here, there's probable cause to believe you committed 2 offenses, a burglary and a criminal mischief. It looks like you might qualify for pretrial release, and if so, then you won't have to post any money to get out of jail, but you'd be ordered not to return to the scene of the offense. Either way, the public defender's office will represent you.
Your Honor, I have a probable cause argument as count 1.
Okay.
Your Honor, this appears to be his old residence where he was evicted out of it. I don't know the process of that. I do know that for a burglary, it can't be, the crime committed therein cannot be trespass. That would not be a burglary. And it sounds like all he was doing is going back into that house to live there, essentially to trespass. Therefore, it cannot be a burglary. I'd only see trespass to the structure and then the criminal mischief, but not probable cause for a burglary. The officer doesn't go on to show that anything was taken in the house. A lot of times when someone is evicted, they steal the copper wiring, things of that nature, or something else.
I'm gonna look up something in the computer here for a moment. My recollection from back in the days of being in the criminal division was that if there's a breaking of a window or something like that, then that's gonna be sufficient for one of the elements. I can't remember which one it is, but maybe you can, because they're alleging that he broke a window, and let's see specifically it was, he broke a fence and a window to gain entry to the home. So let me just take a look at that. 310.07 is the statute that allows proof of entering a structure conveyance at any time stealthily and without the consent of the owner is prima facie evidence of entering with the intent to commit a crime. Ultimately, it's a non-issue because he gets pretrial release and he's not going to be here tomorrow, but there is probable cause based upon that statute. So, not allowed to return. Now, here's a question that I'm going to have you talk to your lawyer first instead of you telling me the answer. Are you all asking me to allow him to return one time to collect belongings?
Your Honor, I don't know if there's much there, but if there's anything, Mr. Tucker would request a one-time visit with law enforcement.
All right, so we'll put that in there. All right, thank you. The way that works is don't just go to the place, contact law enforcement, they'll tell you the procedure, they'll meet you somewhere other than the property, and then accompany you to the property. All right, thank you. All right. Your name again?
Mr. Streeter?
All right, thank you. Have you had enough time to, I don't want to force you to make a decision. Have you had enough time to think about whether you want to reset and have your lawyer present or not?
Yes, sir.
What have you decided?
I want to reset.
Okay, fair enough. We'll reset the case for tomorrow to have your lawyer present. All right, and so just so before you leave, and so there's no confusion, tomorrow there's two sessions. There's a morning session and an afternoon, so let's find out. Will it be for the morning or afternoon? The morning session. So if you talk to your family, tell them it's the morning session that starts, what do you start, 9 o'clock? 9 o'clock.
All right,
All right, thank you. Corey Williams.
Mr. Bland, Your Honor.
The sound in here is terrible. What's your last name, sir?
Bland, B-L-A-N-D.
Okay, so what happened to Mr. Corey Williams?
What happened to Mr. Williams? Yes, he became
All right, there's probable cause to believe the possession of cocaine occurred. We'll reset tomorrow for him to have his attorney present. And, right, and we'll leave him at the status quo until tomorrow the judge there can consider whether or not set conditions of release and whether or not to revoke or not. All right, so let's see. There was a last name Lozen. Did that person bond out?
Yes.
All right, thank you. Do we, when we eventually get to the end, Mr. Lopez Jesus again, I'm sorry, when we get back to Mr. Acosta Pedrosa, will we know before then whether or not there's someone downstairs? Like, remember, that's the one that,
They would have already brought him up.
but if they showed up late, would they have still brought him up?
Yes.
Oh, there you go. Thanks. The sound and the acoustics in here are just terrible. I hear a sound, I don't know where it's coming from. All right, so Mr. Bland.
Yes, sir.
The allegations are that you possess drug paraphernalia and solicited without a permit. It's not, you have an opportunity to hear a plea offer from the state if they're willing to make the plea offer.
Your
If they-
Honor, talking to the state, there is no offer from Mr. Bland.
right, so the public defender's office will represent you. The bond account number 1 is $1,000. The bond account 2 is $100. I'm not revoking the conditions of release, but the case law says that the a judge assigned to the case might do that later, but you have a bond amount now. Right, you understand?
And Your Honor, would you be willing to release him on his own recognizance? It's drug paraphernalia and it's solicitation.
I understand, but he's out on bond on a paraphernalia charge. All right, Susan Bobenkamp? And there's probable cause, set the bond at $250, reset it for tomorrow. Hi there, are you Stacy Emerson?
Yes, Your Honor.
All right, you have 3 counts of petty theft and a paraphernalia. Sometimes the state makes a plea offer, sometimes they don't.
There's not an offer in this case, Your Honor.
All right, there's probable cause to believe the offense has occurred, and the bond will stay at 100, 100, 100, and 500.
Your Honor, trying to determine the reason she was denied pretrial release. I'm not sure if I'm reading this right, but it says unable to verify community ties, no answer.
Correct.
Would she be able to qualify, or if she would be able to qualify, if she can verify some of those community ties, could she get pretrial release?
You're asking them, right?
I'm asking you, Judge.
Well, I mean, I can say bond or pretrial release if she qualifies. I can't force them to take her.
No, I understand. I just want you to put that on the record.
Oh, yeah,
if-
that's
if
fine. I'll
not-
do that. Yeah. Mark Foll, F-O-L-L, is that you, sir?
Yes, sir.
All right, the allegation is possession of drug paraphernalia. Sometimes the state makes a plea offer, sometimes they don't. Is the state able to make a plea offer?
Yes, Your Honor. Point, Your Honor, will accept the offer from the state as adjudication of guilt, credit for time served, and court costs.
All right, so sir, the maximum penalty for this offense is up to a year in jail and $1,000 fine. If you take the plea, you'd be adjudicated guilty, sentenced to, probably, is it 2 days? Is that what the time served is? Yesterday and today?
Yes.
All right, so sentenced to 2 days in jail with credit for 2 days. You'll be released from custody. There are financial obligations, statutory obligations, and we'll give you a year to pay. But you'd be convicted of this offense because you'd be adjudicated guilty. Is this what you want to do?
Yes.
Okay, raise your right hand the best you can. Do you swear or affirm the information you're about to tell us here today is true and correct?
Yes, sir.
All right, you can put your hand down now that you're under oath. Tell us your name.
Mark Full.
That form in front of you lists the rights that a person gives up when they plead guilty or no contest. It lists some of the consequences of entering a plea of guilty or no contest. It lists your right and time to appeal, and then it makes representations on your part, for example, that you're not under the influence of any alcohol or drugs, that you're entering this plea on your own free will, and also lists your right and time to appeal. Did you read and understand everything on that form?
Yes, sir.
Is everything on it true and correct?
Yes, sir.
Then go ahead and sign it. you understand the difference between guilty, not guilty, no contest? I mean, if not, tell me and I'll tell you. You don't need to, it's just a yes or no or tell me. Okay, that's fine. So now I'm gonna tell you. A plea of guilty means you admit it, and then I go ahead and sentence you. If you plead no contest, it means you don't admit it, but you don't deny it, go ahead and sentence you. A plea of guilty or no contest, you get the same sentence. Some people call a no contest plea a best interest plea, and then a not guilty plea means you deny the allegations, you prefer the case go to trial, and you keep the rights that are on that form. Do you now understand the difference between the three?
Right.
Which of those three pleas do you wish to enter to this charge of possession of paraphernalia?
No contest.
And are you entering the no contest plea because you believe it's in your best interest?
Yes.
All right, I'll accept the plea. I'll make the findings on the bottom of the waiver rights form. There's a factual basis to have accepted the plea, and I'll give you the sentence that I told you to receive. Do you have any questions?
No, sir.
All right, thank you, sir. Thank you. Hi there, your name, please?
Michael Hedden.
All right, so you have a trespass charge and a resisting officer without violence charge. Sometimes these cases, the state's able to make a plea offer and sometimes no. So,
There's not a plea offer in this case, Your Honor.
all right, give me a moment to read the police report here. All right, so there is probable cause, and each one of the cases, the bond is $500 or pretrial release if you qualify. You might ultimately qualify, and then you wouldn't have to post a bond, but I don't have any control over whether you do or don't, so they have an alternative bond of $500. Either way, don't return to the 7-Eleven. All right, your name, please?
No.
All right, thank you. There's probable cause to believe you committed the offense of trespass. I'm not going to revoke the conditions of release in the case that you're out on bond on, but your bond on the new case is $1,000. Actually, the state might make a plea offer, so what's the offer?
There is an offer. It's an adjudication of guilt, credit for time served, and court costs.
All right, or you can do that.
Your Honor, Mr. Lano will accept that, or Mr. Jean will accept that.
Sir, raise your right hand the best you can. You swear or affirm the information you're about to tell us is true and correct?
Yes.
All right, thank you. You can put your hand down now that you're under oath. And now that you're under oath, tell us your name again, please.
Leno, Jean.
Thank you.
Jean Leno.
Thank you, sir. The waiver rights form that you sign there lists the rights that you give up by pleading guilty or no contest. It lists some of the consequences of entering a plea of guilty or no contest. And it makes some representations on your part, as well as lists your right and time to appeal. Did you read it and understand it before you signed it?
Yes.
Do you have any questions about anything on it?
No.
Is everything on it true and correct?
Yes.
Do you understand the difference between guilty, not guilty, no contest? You don't need to explain it. I just want to know if you know the difference. If not, I'll tell you.
No contest. What is no contest?
It means you don't admit it, but you don't deny it. It means I'm not contesting the charge, but you still get sentenced, and you'd be sentenced to that adjudication, 2 days in jail, you'd be released from the case today, and then you pay the required statutory costs. So, does that explain to you what no contest means?
Yes.
All right. And guilty means you admit it, and not guilty means you deny it. So which of those three pleas do you wish to enter to this charge here?
I I have nothing to say because I didn't do anything bad. I just was trespassed.
Right.
I didn't know I was supposed to be back there, and then so I just I got called 911 on
Right.
by a guy named Jeff Franklin, and then I just went back to jail for trespassing.
So you have the right, if you want to say not guilty. And then you can bond out of jail, and then your lawyer can fight you. Fight the case on your behalf, fight for you on your behalf, the case. Or you could accept the plea offer. It doesn't matter to me. You have to make the decision what's in your best interest. Take the plea offer and resolve the case, or turn down the plea offer and let your lawyer fight the case for you.
Yes, sir.
So just, it doesn't matter to me, just tell me which one you want.
I'll take the plea offer.
Okay. So to the charge, do you want to plead guilty, not guilty, or no contest?
Not guilty.
Okay. Sometimes it sounds like you're saying not guilty, guilty.
Because I was trespassed.
Your Honor, Mr. Jean will plead guilty.
A plea of guilty means you admit it, go ahead and sentence you. Is that what you want to do? Just a little bit louder.
Yes, sir.
Okay.
Yes, sir.
So I'll make the findings on the waiver rights form. There's a factual basis to have accepted the plea, and I'll give you the sentence that I told you'd receive. Do you have any questions?
No.
All right, thank you, sir. Anthony Watson?
Yes, sir.
Lake County has a no bond warrant for your arrest. So once you're released on the Orange, let me make sure. He's in jail on the Orange County case also? Oh, okay, okay. Lake County will be told to come and pick you up, and they should pick you up. Usually it's 24 hours, but sometimes it takes a couple days, but by the end of the week.
My court's tomorrow.
Do you have a lawyer?
I was never had a public defender, none of that. They were supposed to talk to me and contact me, but nobody never has. My lady been trying to drop the case.
Well, I don't know if you have more, hold on a second.
My court's tomorrow. I don't know how.
Wait, in Lake County or in Orange County?
Lake County. I should not be here because my court's tomorrow. I don't know why I got a warrant for not going to court when it's tomorrow.
Well, I don't know if it's for not going to court. It could just be for revoking conditions of release because it says showing charge for order to revoke bond. So it might not have been a failure to appear. It might have just been some other reason.
Because the police officer told me the failure to appear when he looked up.
What's that? I'll take a look here. state filed a motion to revoke bond back on August 6th in your Lake County case. The basis for the motion to revoke bond was that you were arrested by the Orange County Sheriff's Office for committing a new law offense violation of pretrial release. A copy of the probable cause affidavit was attached to the motion. So let me just take a look. Hold on a moment. And the teletype is on order to revoke bond. So that's what it appears to be, not a failure to appear.
My bondsman never told me none of that. I called him this morning. He never, the emails that never showed up on there. There was any bond.
This was not done for failure to appear in court. It was done because apparently the judge must have been convinced that you committed a new crime, and as a result of that new crime where you were out on bond, revoked the conditions of release, and so that was a warrant that was issued for your arrest. That's what it appears to be.
Even if I got court tomorrow?
Well, Lake County will be told to come and get you. I don't know if they don't wait till Monday to tell them, or if they tell you then. Well, actually, let me just see if you have a lawyer representing you. You do have a lawyer representing you. You have, yeah, and you have the public defender's office over in Lake County representing you. So if they look, there's a website called vinelink.com. It allows lawyers to look all over the state to see if someone's in custody before another judge issues a warrant for a failure to appear. So hopefully your lawyers will do that for you, but I have no control over that, and I can't require the assistant public defender here of the Ninth Judicial Circuit to contact them for you.
I will, Judge.
I mean, he might, but if he doesn't, it's not, I mean, you can't hold it against him. But do you need you got the case number, or do you need it?
I got it.
Okay. Yeah, and I'm not taking any action on his Orange County case. That'll just.
All right.
All right. All right, so might as well do 4 at a time here. Well, no, so, I don't want to mispronounce names. It looks like Alan, Jaquez, and Reddy.
Yes, Your Honor.
So, but we're waiting for the 4th one to.
Okay.
All right. All these people are here. That was the one that were all reset for the same reason.
Yes.
All right. Any further statements under oath from the state?
No, Your Honor.
All right, then here we go. I hate calling people by their first name in court. Stanley, how do you pronounce your last name?
Aladdin?
Aladdin, okay. So in your case, on count number 1 of case number 2019 CF1, well, state has no more information, but did you have any case law that might support that I can make a finding that it's heroin? I mean, absent that, I would have to ROR on them, count 1. No? All right, so no case law or anything?
No, Your Honor.
Okay, so ROR on count number 1, your bond on count number 2 will be $100.
What's count number 2?
The cannabis. Right, yeah. Okay.
Judge, there was he did have an open case. Yesterday I talked to, I requested that we hold off on revoking bond on that case.
I thought it was the other gentleman who, the other case it was Mr. Jaquez, because his case was he was out on bond on just a simple cannabis charge. So why would I revoke a bond on some case that's never gonna get charged?
Was bond revoked and
Yeah,
I didn't have, okay, right, so it's already been revoked?
right.
And then plus, was the fugitive warrants addressed as well?
That was just a long way of saying no.
I know, I just
All
want
right.
to get
All right, so then on. On Mr. Jaquez, so then on his,
Well, we have Joshua Allen also.
yeah, but just on a,
Okay.
I mean, they're all, if I'm not mistaken, all three, we have Jaquez, Allen, and Redding right here in the courtroom, right? Yeah, okay. So on Mr. Jaquez, no further additional information from the state. So then on his count number 1, he'll be ROR'd. The bond on count 2, $100 remains. And then I'm not revoking the conditions of release on the 2019 MM5569 case because that was the one that all the charges is cannabis and the state hasn't, we were told yesterday the state hasn't filed on any cannabis charges since July 1st, or offense dates after July 1st. Then that brings us to Joshua Allen. All right, so Mr. Allen, your state hasn't had no more additional information, therefore, with regard to count number 1, you'd be ROR'd, and the bond on count 2 is $100. All right, thank you. And then Mr. Redding.
Just 1 second.
Mr. Redding?
Yes, sir.
Okay. You said just a minute?
Yeah, I apologize, Judge.
That's all right.
Thank you.
All right, so counts 2 and 4 were rolled over to see if there was any additional information. The state said they have no more additional information, so on counts 2 and 4, you'll be ROR'd. The bond on count 1 is still $1,000, and bond on count 5 is $100.
Thank you.
All right, thank you. Are you Thomas Culver?
No.
No, okay, your name, please?
Stephen Cameron.
All right, thank you. All right, so Mr. Culver's medical, let's see, so previously appointed to the PD, found probable cause. All right, we'll reset it for tomorrow. Yes, ma'am. Mr. Cameron, you have 2 cases here, 19 CF 193 and 18 CF 17926. Both of these are no bond warrants for your arrest for violation of probation. Your lawyer can go in front of the judge to try to get you a bond. The public defender's office will represent you, okay?
Okay,
You have a question? Maybe
yeah,
ask
why do
him.
I have 2 violations?
You have 2 separate cases, and in each one of the cases, it appears to be the same violation of probation. So it might just be, maybe you didn't understand what I said.
Okay.
Each case has an alleged violation of probation, so the jail's holding you at no bond on 2 separate cases. Yeah, but I don't.
I'm representing too. It's just crazy.
All right, can you please tell us your name?
My name's Joseph Dyer.
Mr. Dyer, you're in custody on a violation of a county ordinance for possession of open container, punishable up to 60 days in jail, $500 fine. Sometimes the state makes a plea offer, sometimes they don't.
Your Honor, Mr. Dyer wanted to represent himself, but I did inform Mr. Dyer as a friend of the court that the offer here is adjudication of guilt, credit for time served, and court costs.
Is this what you want to do?
Yeah.
All right.
Yes, sir.
Now, well, let me place you under oath. Raise your right hand the best you can. Do you swear or affirm the information you're about to tell us is true and correct?
Yes, sir.
All right, thank you. Put your hand down now that I've placed you under oath. And then go ahead and tell us your name now that you're under oath.
My name is Joseph Dyer.
All right. Prior to coming in here, did you have a chance to read and understand the waiver rights form?
I was so focused on my truck that got stolen, I didn't have even a chance to even think about that. I'm thinking about my truck that got stolen, and I had open
Let me just go over
beer.
a couple of things with you, and then at the end of it, you could tell me whether you still want to take the state's offer.
Yes, I want to take the state's
Well, hold on,
offer.
I gotta, since you might not have, is that the waiver rights form right there? Have you ever seen that before? That form there, have you ever seen it before?
Yeah. Yes, see it right now.
If you've previously have seen that form and have read it and understood it, go ahead and sign it on the bottom if you want to take the state's plea offer. All right, to the allegation that you possess as open contain, what's the offer or time served, you said? So adjudication, 2 days in jail, you've done the 2 days, you'd be released from custody today, and there's a mandatory cost you'd have to pay, and we'd give you 1 year to pay it. Is that what you want to do?
Yeah, what does that cost?
There's this court cost, there's a fee for the state attorney's office prosecuting you.
How much is it?
All right, no,
You know how much it is?
yeah, we're figuring out right here.
Okay, I just want to
Hold on,
know.
what's the number?
I don't know.
273,
Okay, yeah.
expensive beer.
Oh, that's what I was gonna say. Okay,
All right, do you still want to take the plea offer or no?
I just gave y'all $10,000. I mean, God, how much money you don't want?
I didn't get it.
273 now.
You don't have to take it, you can
I'm
turn down the
No, I'll
offer.
pay you. I always do pay you.
All right, so do you want to plead no contest, not guilty, or
Running
guilty?
me into my grave, but. Yeah, no contest.
Are you entering the no contest plea because you believe that's the best way to resolve the case for you?
Yes.
All right, I'll make the findings on the waiver rights form, there's a factual basis to accept the plea, and I'll give you the sentence that I told you you would receive. Any questions?
Thank you. No, sir.
All right, good luck. Angel Glover.
There's a plea from Ms. Glover. She'll be accepting that plea, Judge.
What's the offer?
Adjudication guilt, credit for time served, court
So,
costs.
the charge you have, this possession of open container, is punishable up to 60 days in jail and a $500 fine. If you plead guilty or no contest, adjudication, 2 days in jail, you've already done the 2 days, you'd be released today, but there's that mandatory cost, you just heard what it is, at $273. Is this what you want to do?
What you mean the mandatory, what do you mean?
Oh, the legislature has decided that they want to fund various things in the state. You know, police, parks, whatnot, employees, judges, public defenders, prosecutors. So one of the ways that they raise money is like property taxes. Other ways they raise money is by requiring court costs. So in this case here, if you accept the plea, there are certain costs that I'm required by law to impose.
And how long do I have to pay that?
1 year.
1 year? That's fine.
All right, so prior to coming into the courtroom, did you have a chance to see the waiver rights form that lists the rights that you give up by pleading guilty or no contest? That form right there?
Yes,
If-
I've seen that form before.
All right, if you've read it, understood it, and everything on it is true and correct, go ahead and sign it and hand it back to the corrections officer.
I have another question also.
Yes, ma'am.
I have a warrant in Jacksonville. I'm trying to see how many days do they have before they come get me. It's a child support warrant.
Okay. So what happens is, once that is served on you, and they might serve it upon you as soon as you get released from custody under this case, once they serve it on you, then they're told to come and get you. They're
So
supposed to
you
come and
tell
get,
me- You saying I get released today and then it's up to them to come serve me another one, or I stay in jail?
well, what
until-
happens is our jail will release you on this case here that we have today.
Mhm.
They look in their system. If there's any outstanding warrants or writs, then they'll serve it upon you. If you're served with a writ or a warrant, they contact that other jurisdiction and tell them to come and get you. And if they don't pick you up within a certain number of days, you get brought back in front of a judge, and that judge could allow you to be released. Now, let me just ask if that's the same for child support, because obviously we don't want to hold people in here for too long. Same thing as for child support
Yeah,
writs?
it's for child support.
Yeah.
Yes, it's a writ for child support, it's already been served out of Duval County.
All right.
They'll be,
But this-
teletyped today to let them know she has no locals, and they'll be given 72 hours.
There you go. So by the end of the week, they'll either get you or they'll release you.
By Friday?
Yeah, but I can't guarantee.
Okay.
But that's what happens at some point in time. You
But
should
they
drop
have
back.
72 hours to come get me.
Well, we have an administrative order, but then what happens is then you're brought 72 hours from start of business Monday, because they don't pick people up on the weekends. If you don't get picked up within the 72 hours, usually you're brought before a judge to address it. When I was a judge assigned to the jail, I used to say, all right, I'm gonna give them 24 more hours to pick the person up, and if not, they get released. I don't know how the judges handle it now.
Okay. All right.
So good luck.
Thank you.
Yes, ma'am.
Your Honor, Mr. Reed has an offer of an adjudication of guilt, credit for time served in court costs.
Is that what you want to do?
Yes, sir.
That form, well, let me place you under oath here. Do you swear affirm the information you're about to tell us is true and correct?
Yes, sir.
All right, now that you're under oath, tell us your full name.
Eddie James Reed.
Mr. Reed, the allegation that you solicited without a permit yesterday, it's punishable up to 60 days in jail and a $500 fine. If you plead guilty or no contest, you'd be adjudicated guilty, sentenced to the 2 days in jail that you've done. You'd be released from custody today. You'd be ordered to pay the required cost that the clerk has told us is $273, and we give you a year to pay it. Is that what you want to do?
Yes, sir.
If you've read and understood that form, go ahead and sign it there and hand it back to the corrections officer. Thank you. To this charge, there are 3 different types of pleas. There's guilty, not guilty, no contest. Do you understand the difference between the 3?
Yes, sir.
Which of those 3 pleas do you wish to enter to this charge here?
No contest, sir.
Are you entering the no contest plea because you believe that's the best way to resolve the case for you?
Yes, sir.
All right, I'll make the findings on the waiver rights form. There's a factual basis to accept the plea, and I'll impose the sentence that I told you you'd receive. Do you have any questions for me?
No, sir.
All right, thank you. Good luck. Here's the reset. No, I mean, the record paperwork. I just take a look at that. So stand up here. Okay, I didn't, just one minute. All right, Mr. Acosta Pedrosa?
Yes, sir.
All right, welcome back. We waited, they didn't show up. But it doesn't mean that your attorney can't go in front of the judge assigned to the case at a time that works out for both you, for the listed victim, and for your attorney and the state to address the conditions of release in the future. So as I said before, there was probable cause, order no contact. Did you read and understand that no contact order?
Yes.
All right, if you read and understood it, go ahead and sign it and hand it back to the corrections officer. So no contact with the listed victim, maintain a separate residence, no weapons or firearms, no return to the victim's residence except for one time with law enforcement, and don't possess or consume any alcohol. And the bond on the case is going to be $500, and I can't add pretrial release to that, can I?
Does he not qualify for pretrial release?
No.
All right, so $500 bond. But
Excuse me, sir.
all right, do you understand?
Is anything like I can do it less? I know the thing is I have checks in my house, like I can catch it, but then my credit card right now, I have only maybe $200. That's it right now in my credit card. I want it, pay the money, whatever you say, please you give me a break on that one, or I can go.
Based on the information that we're just learning from Mr. Acosta Pedrosa, Your Honor, I believe like it sounds that he has money on a card, which I believe he could use to pay the bond through the jail. Is there a chance that we can lower that cash bond to $200?
Yeah, that's fine, $200 bond.
Thank you, Your Honor. $200.